when an employer calls me and they received an EEOC complaint, there are certain steps that I have to take, and so does the employer. The important thing with the EEOC or with the New York State Division of Human Rights, in the event that an employer receives some sort of a complaint by an employee through one of those agencies, the most important thing is to cooperate with those agencies, in my opinion. They ask for a number of different documents. They ask for things that you don't think are going to be applicable or in any way relevant. Tough beans. The employer should go ahead and give it to them anyway, because you want to have the spirit of cooperation with the investigators, because they are ultimately in a position to hold things against you that you don't provide to them. Thereafter, you have to make yourself available to the agencies for meetings, and they do happen, where they'll call you in and say, well, we want to have an investigative gathering where we're going to have the claimant, we're going to have the company. You're not going to be allowed to talk to each other, but we want to talk to you in each other's presence. It's called investigative face-to-face conferences. And of course, you have to show up with who they want you to show up with. And you have to prepare those people in terms of demeanor and in terms of what they're going to say and not say. And an employer oftentimes has to be prepared to mediate right on the spot, right up front. In other words, talk settlement even early on. Most employers that I represent don't want to hear that. Most employers are saying, we didn't do anything wrong, why are we going to pay anything? But they have to have, again, with the spirit of cooperation with these investigative agencies, you have to indicate to them, through some conversation, that you're willing to be cooperative and work with them. Sometimes that includes making modest settlement offers early on.